Good morning, everyone, and happy Tuesday to everyone out there. Now, I do apologize that you can't see me today. I'm having some technical difficulties with my camera, so I hope you intently stare at my picture and imagine my mouth moving as I go through and explain what's going to go on for today's session. My name is Rain McGreevy, and I'm from Stromer and Company. We are one of the sponsors here of the MAID program, and we are so thankful that you're able to come here today and join us with our session. Today's topic that we have is assistance animals and how they impact associations. So we're very, very fortunate to have Richard DuBose from Godey DuBose and Cross, as well as Christy Mays. Richard, would you take a moment and introduce yourself and maybe tell some of the new attendees that we have joining us a little bit about the MAID program?
Okay, Richard DuBose, Godey DuBose and Cross. It's my partner, Christy Mays. She's going to do the presentation today. MAID is a joint effort between Stromer and Company, CPAs, and Godey DuBose and Cross to provide monthly free seminars like this on things related to the community association world. It stands for Managers and Directors Education in Florida. So MAID in Florida. We thought that was clever. In any case, every month we seem to have more and more people. So we're very happy that you're tuning in. This will last about an hour, maybe an hour and 10 minutes. There'll be an opportunity for questions after Christy's presentation. I'll let Christy introduce herself, but today's topic is assistance animals, which is the bane of our existence in the legal world. I'll let, unless you have more to say, Rain, I'll let Christy take it away.
Go ahead, Christy, you can go ahead and take it away. And any of our participants, if you have questions, just type them in the questions, or I'll go ahead and get to those. We're probably going to hold off on those until the end because a lot of questions will probably answer themselves as Christy goes on. Now I will turn it over to you, Christy.
Good morning, everyone. As Richard and Rain said, we're here to discuss the highly coveted topic of assistance animals. Many of you have likely already dealt with issues involving assistance animals, and today hopefully we'll go over some of the nuances or maybe some issues that you haven't dealt with. And by all means, at the end, if you have any questions, feel free. We will answer any questions that you have. So I'm going to go ahead and share the screen so we can get the PowerPoint started. Okay, Rain, I'm going to need you to allow me to share my screen. Are you able to do that?
Yep, try again. I think it should let you go ahead and do it now.
Yep, there we go. Let's see here. Okay, are you able to see the PowerPoint?
Yes.
Okay. All right, so we will get started. So what is the Fair Housing Act and what is the Americans with Disabilities Act? Both of those you will hear come up when most likely when a resident makes a request for an assistance animal. You may hear them say, well, according to the American with Disabilities Act, I'm allowed to have this animal. Most people are not very well versed. They don't understand the difference between the Fair Housing Act and the American with Disabilities Act. And there's a distinct difference between the two. The first one, the Fair Housing Act, is what's going to be applicable to associations. So basically the Fair Housing Act applies to housing providers. So it protects people from discrimination when they're renting or buying a home, getting a mortgage, seeking housing assistance, or engaging in other housing-related activities. The other housing-related activities is where associations will fall. Now, when it comes to the Americans with Disability Act, that prohibits discrimination against people with disabilities in several areas, including employment, transportation, public accommodations, communications, and access to state and local government programs and services. So typically the ADA won't apply to associations. Now there's very limited circumstances where the ADA will apply. Those, some of those instances may be if you have a mixed use condominium, where you may have businesses that are maybe on the lower level of the condominium, and those businesses are open to the public. in that instance, the ADA would apply to those units, the commercial units. If you have a community where maybe the clubhouse opens the amenity, or the association opens the amenities to the public for maybe an Easter egg hunt or a Christmas event, once the association opens the amenities to the use of the public, at that point, the ADA would be applicable. So it's very rare that the ADA would apply. Typically, you're going to see it's the Fair Housing Act. Okay, now what is a reasonable accommodation? So a reasonable accommodation is when there is a change, exception, or adjustment to a rule, a policy, or a service that may be necessary for a person with a disability to have an equal opportunity to use and enjoy a dwelling, including the public and common use spaces. So typically you're going to see an association is going to either be faced with a reasonable accommodation request or a reasonable modification request. An accommodation request is where you will typically see your request for an assistance animal. Other requests may be if you, basically anytime that a resident asks the association to change its policies, whether it be a no pet policy for the animal. If you have a resident who needs a trash pickup, they can't take their garbage to the dumpster, there's a maintenance man who it's reasonable for him to pick the trash up, that's going to be a reasonable accommodation. It's a change to a policy. And then there's, like I mentioned, the modification, that's going to be where you are actually modifying the common element or a unit to allow for maybe a ramp or a pool chair to be put in. So today we're going to focus on the reasonable accommodations, which is where the assistance animal request will be made. So when a resident and community association requires an assistance animal and the association has a pet policy, a reasonable accommodation request for an assistance animal may include a request to live with an animal when the association has a no pet policy, or perhaps a request to waive a pet deposit, some type of fee or other rule that would apply to the assistance animal. So associations may see that they may have a request where they allow pets, however, there is a fee that needs to be paid for, they have an amenity fee where owners that walk their pets may have to pay for the little doggy bags, or there's like a small fee. Those fees would not be applicable to an owner of an assistance animal. Okay, what is an assistance animal? An assistance animal is an animal that works, provides assistance, or performs a task for the benefit of a person with a disability, or that provides emotional support that alleviates one or more identified effects of a person's disability. Now, the most important takeaway from today, I would think, is that everybody needs to understand that an assistance animal is not a pet. The pet policies do not apply to assistance animals. Okay, there's a total of 3 types of assistance animals. We are only going to discuss 2 today. There's a third type, it's therapy animals, but those only are used in settings of nursing homes, schools, more public accommodations. The 2 that we'll discuss today are emotional support animals and service animals. Emotional support animals are, you're going to see more often, and that is, emotional support animals are considered animals that provide emotional assistance to their owners. Emotional support animals are regulated by HUD under the Fair Housing Act. Now, service animals are specially trained dogs or miniature horses that perform a task for its owners. They're regulated by several federal agencies, including the Department of Justice, the EEOC, and the Department of Transportation, and as we mentioned, the ADA. HUD interprets the Fair Housing Act to require access for individuals who use service animals. Associations should initially follow the analysis that the Department of Justice, which we will, I'll get to in a few minutes, has determined to assess whether an animal is a service animal under the ADA. So if you look back to what I just mentioned, that especially trained dog or miniature horse is the only animal that can be used as a service animal. So when you see on the news where there's a peacock or alligators, those cannot be used as a service animal. The ADA specifically defines just the trained horses and dogs. Okay, obligations of an association in response to an assistance animal request. So if you have a resident who is making the request for the assistance animal, the association must allow a reasonable accommodation to a no pet policy when it may be necessary to afford that person with a disability the equal opportunity to use and enjoy the dwelling. So individuals with a disability may request to keep the assistance animal as a reasonable accommodation to the no pet policy. Okay, so the Fair Housing Act requires an association to allow a reasonable accommodation of an assistance animal in situations that meet the following conditions. First, certain documentation should be provided. Now, not all instances, when it comes to service animals, you may not need that documentation, but we'll address that. But when it's an emotional support animal, there is documentation that will be required. If the association is unable to demonstrate that the granting the request would impose an undue financial and administrative burden on the association, the request would fundamentally alter the essential nature of the association's operations. So both of those we're rarely going to see that they would apply in any type of assistance animal request. Those are typically going to be when it's going to be a reasonable modification request. The remaining two, the next one may be applicable to specific assistance animal in question, would pose a direct threat to the health or safety of others despite any other reasonable accommodations that could eliminate or reduce this threat. And the request would not result in significant physical damage to the property or others despite any other reasonable accommodation that could eliminate or reduce the physical damage. So that one won't typically be applicable for assistance animals either. Okay, so oftentimes we get the question of what happens when a request is made for an assistance animal, but the neighbor is allergic to the animal. Most often it's going to be dogs or cats. This was actually addressed at the Iowa Supreme Court level. And in that case, there was a neighbor who was highly allergic to dogs, but the landlord feared denying the request for the accommodation as he thought he would have a fair housing complaint filed against him. So the landlord approved the reasonable accommodation request for the animal, but allowed the neighbor to use a separate stairwell and also set up a special air purification in the unit. The neighbor still happened to suffer allergic reaction to the dog, and the court at that point, it went to the Supreme Court, and the Supreme Court held that the landlord's accommodation of the emotional support animal was not reasonable because the tenant with pet allergies had priority in time. They lived there first prior to the owner who was requesting the emotional support animal, and determined that by the dog's presence, that it was posing a direct threat to the first owner's health, the first owner to live there. The court also held that the tenant suffering the allergic attack was entitled to recover on her claim of breach of lease and breach of covenant of quiet enjoyment, and they remanded the case for an award and requested 1 month of rent in damages. Now, it's important to realize that this is not the common approach that's taken by the court. Florida does not have any similar case law on this, so it's undetermined whether Florida would take this stance. We typically would tell anyone who has a neighbor who is requesting that the dog be denied or the animal be denied based on an allergy, that they first try and negotiate some kind of solution that would work for everyone. If you're unable to do that for whatever reason, then we would seek advice of legal counsel to see how we could if we could work it out for all parties involved. Okay, very common question that will come up is, can the animal be denied based on being an aggressive breed and therefore be considered a direct threat? If you recall, one of those 4 criteria that the association can deny on is if there is a direct threat. So according to HUD, they address this by stating that a determination that an assistance animal poses a direct threat of harm to others must be based on an individual assessment that relies on objective evidence about the specific animal's actual conduct. So basically what's saying in more simple English is that if you have proof that that specific animal posed a threat in the past, then that's something that can be relied on. If you are saying that because the animal is a pit bull, a Doberman, or a Rottweiler, we can't allow that animal into our association because they're a direct threat to the other owners, that is not sufficient. You have to show that it's that specific animal. Okay, so now we're going to discuss service animals. Service animals, as we mentioned, they are regulated by the ADA. It only applies to dogs and miniature horses. And just to digress a little bit on miniature horses, I actually have an association right now who is dealing with a miniature horse. And typically, people will ask why miniature horses. And I actually ran into somebody who he had a miniature horse as a service animal. And I got to talking with him, and he said to me that the reason he uses a miniature horse is because he has a disability that causes him to faint, but he can feel when he's going to faint, he feels it coming on. So what he does is he can position himself to lean on the horse, and the horse is more sturdy than a dog, and it will break his fall. So that there are reasons that a miniature horse may be more beneficial to a disabled person than a dog would. Service animals must be trained, and they must be able to perform a task. So there's a lot of information on this page, but this is basically the process that you would go through if there is a resident asking for a service animal. So first you're going to ask, is the animal a dog or a miniature horse? If it's yes, you can proceed to the next question. If no, it doesn't mean that you shouldn't approve it. It may still be an emotional support animal that would be approved through a reasonable accommodation. So if no, then you would then switch to the process for approval on an emotional support animal. If the answer is yes to the preceding question, you would then ask, is it readily apparent that the dog is trained to do work or perform tasks for the benefits of an individual with a disability? So if it's readily apparent, you're going to see that it's going to be somebody who has, they're in a wheelchair and the dog or the horse is pulling them. The individual is blind or has low vision, so you'll see that they have a white stick, or they may, it may provide assistance with stability, like we mentioned. So if the answer to that question is yes, there's no further inquiry that needs to be made. It's considered a service animal, and it should therefore be approved as a service animal. If the answer to that question is no, then you're going to proceed to the next 2 questions, which is inquiries that the association can make to the owner of the service animal. And they can ask, is the animal required because of a disability? You'd never want to ask the nature of the disability, and that goes for emotional support animals and also service animals. All they need to respond is yes, that they have a disability. And for a service animal, you do not need documentation for the disability. Secondly, you can ask, what work or task has the animal been trained to perform? So if the answer is 1, to 1 is yes, and then they show that the animal has been trained to do work, it should be approved. If the answer to either question is no, then the animal does not qualify as a service animal. But again, you may have to go through the steps for the emotional support animals, as at that point, it may be considered an emotional support animal. Okay, qualifications for performing work or a task. So performing work or a task means that the dog is trained to take a specific action when needed to assist a person with a disability. If the individual identifies at least one action that the dog is trained to take, which is helpful to disability, then the dog should be considered a service animal and permitted in the association. housing providers should never make further inquiries. We see a lot of times where the boards will kind of want to investigate and try and prove that the animal really isn't necessary. The board should never do that. If they have those inquiries, that they have the sufficient responses to allow them to be a service animal, the inquiry should end right there. If no specific work or task is identified, then as I mentioned, you want to start the process for the emotional support animal criteria. Okay, and now we're going to transition into emotional support animals. This is likely what we, as managers, you'll see many more of these requests. And basically, emotional support animals, they must be approved if the owner of the animal can provide specific documentation. Unfortunately, we see this as a big loophole. We see that many owners can get this documentation very easily, but if they do receive the documentation, they provide it to the association, and the emotional support animal must be approved. So basically, what does the documentation have to provide? It has to first show that the person has a disability. That is it. It does not have to say, it should not say what the disability is. There should be no inquiry as to what the disability is. The disability can be any physical or mental impairment. So it may not be a disability that you can see. Most oftentimes, it's going to be some kind of mental disability. And I will get into disabilities on another slide. Secondly, the documentation should show that the animal ameliorates the symptoms of the person's disability. So the letter can be as simple as, yes, I am treating this person, they have a disability, and the animal ameliorates the symptoms of that disability. That's sufficient. The animal should be approved. Okay. In contrast to service animals, emotional support animals can be any type of domesticated animal. It's not just limited to a dog or a horse. So this is limited to domesticated animals. And this is just a recent change within the last few years. It used to be where you could have any animal as an emotional support animal, but now it has changed in 2020 to only allow domesticated animals. You cannot place a restriction on breed or size. So many times we'll hear associations come to us and say, we have a 25-pound pet weight limit, or we have an aggressive breed restriction. Those do not apply because, again, this is not a pet. So any of those pet restrictions are not applicable. Exotic and farm animals are only allowed if they perform a task. So there is a small area where you can have an exception to allow an animal that's not domesticated, and we'll get into that in a minute. So emotional support animals do not require professional training, and they only need to provide emotional support to the owner. So the owner can have anxiety, depression, any type of mental disability like that, and that will afford them the right to have this pet. We have had instances where they have asked for multiple emotional support animals, and there are instances where it should be approved. We've seen where there's case law that says that they can have an emotional support animal for each of their disabilities. So we had a situation where we had a lady who had 6 dogs. Her and her mom lived in the unit. They each, and it was a no pet policy, they each came forward and said, we each have 3 disabilities, anxiety, depression, and something else. And we each need a dog for each of these disabilities, and it had to be approved. There's also was a recent case where there was an owner who requested 2 assistance animals for 1 disability. And they found that because one animal would comfort her all of the time, and a separate animal would comfort her when she had very high anxiety, that both animals should be approved. So restrictions on pets do not apply to assistance animals, as we mentioned. However, if the assistance animal is a nuisance or they become aggressive, at that point, there are other provisions in the association's documents that may allow us to have the assistance animal removed. Again, pet deposits cannot be required of owners of assistance animals. Okay, emotional support animals and service animals must be allowed on the common areas. So that includes the clubhouse, the fitness area, the pool area. The health department has accepted that assistance animals can go into the deck area of a pool. They can go into eating areas, but they have stated that it is a health concern for them to actually physically go in the pool water or be in a kitchen that may be at a clubhouse. So outside of the actual pool water or a kitchen, assistance animals should be allowed anywhere on the common areas. If a neighbor is aggrieved by an assistance animal, the neighbor has the burden to show that he or she would be impacted by the assistance animal. So that's basically what we discussed with that Iowa case. You really want to work to get a solution that will help all parties and hopefully allow the assistance animal to reside with the owner. Okay, what animals qualify as emotional support animals? So acceptable animals would be the traditional animals that are kept in the home: dogs, cats, small bird, rabbit, hamster, gerbil, other small rodents, fish, or turtles. For purposes of this assessment, unique animals such as reptiles other than turtles, barnyard animals, monkeys, kangaroos, and other non-domesticated animals are not considered common household animals. So if the individual is requesting to keep a unique type animal that's not domesticated, and they can show that the specific animal has been trained in some way to assist them, then that animal should be approved. Typically, you're going to see this in more like a service animal type thing where they're trained to do a task. There was a case where there was a lady who she had a spinal cord injury. She was confined to a wheelchair. She was unable to, she had very poor and limited motor coordination of her hands. So she had a monkey who would help her to get things out of the fridge, help her open items, and she could show that this monkey was trained to do these tasks. So in that instance, the monkey should be allowed. The reasonable accommodation should be allowed, even though it's not a domesticated animal. Okay, and then going into observable and non-observable disabilities. Typically, you're going to see your observable disabilities are related more to service animals, and non-observable are going to be related more to emotional support animals. So observable, as we mentioned, is going to be a mobility issue or maybe blindness, where the non-observable is going to be something that's more related to a mental health issue. Okay, information for the emotional support animal, when they have to provide, when the owner of the assistance animal has to provide documentation to show they have a disability, they can provide several different types of documentation. It can be a determination of disability from a governmental agency. It can be a receipt showing that they received some type of Social Security disability benefit. It can be that a document or a voucher showing that they receive housing assistance for a disability, or they can get documentation from a medical provider which states that they have a disability. Now, the medical provider can be, it does not have to be just a doctor. So it can be a nurse practitioner, a physician's assistant. It can be some type of mental health provider. So if you get a letter and you see that it's not a physician, it doesn't automatically mean that it's not sufficient to approve the animal. Okay, request for assistance animal. The request for an assistance animal, it can be made, it doesn't have to be by the owner of the animal. It can be made by maybe a parent requesting it for a child, or an adult child requesting it for their elderly parent. And the request does not have to be written, it can be oral. Okay, and documentation from the internet. So many times we will see the certificate that's printed from the internet. You can go on the internet right now, pay $50 and get a certificate that looks just like this. You click off a few boxes and you have your certificate. HUD has now said that these certificates are not by itself sufficient to show that the individual has a disability. So if you get one of these certificates, and Florida law has also adopted that standard. So now if you get the certificate, we can still go back and say, we need that documentation from the medical provider or one of those other types of documentation that I just mentioned. Okay, out-of-state medical providers. So you may get a letter from an owner of an assistance animal, and it may be from an out-of-state medical provider. So there are providers who will you can go purchase a letter from one of these providers. They're out of state and it's $50 on the internet. So they've now required that the documentation, if it comes from an out-of-state provider, that the individual must show that they've had at least one in-person visit with the medical provider, or that the medical provider is licensed as a telehealth provider. So if you get a letter and the license is from another state, we can look into that and determine if the letter should be approved. Okay, what if the assistance animal is obtained before the request is made? So we often see where we have a no pet association and the animal is adopted or brought into the association. And once we send a letter to remove the animal, we get back the documentation that it is all of a sudden an emotional support animal. Unfortunately, there's not much we can do about this. A request for the reasonable accommodation of the animal can be made at any time. It can be made before or after acquiring the animal. So while HUD may create an inference that if it is investigated that it maybe wasn't done in good faith, there is absolutely no requirement that the request must be made for the animal prior to obtaining the animal. Okay, so now we're going to get into what to do if a complaint is made and how the association should respond to the complaint. Basically, if at any point any of your associations are going to deny any type of assistance animal, they should seek legal counsel first. There's very heavy sanctions for and any of these HUD claims that arise for assistance animals. And we always recommend that let us look it over, let us determine that you do have proper grounds to deny the animal before it is denied. If you feel comfortable approving the animal, you see that you have the proper documentation, that is fine. But again, when it comes to denying, we would suggest that you seek legal counsel before the denial is made. Okay. The Fair Housing Act complaints concerning the denial of reasonable accommodations and disability access comprise almost 60% of all fair housing complaints. Complaints involving requests for reasonable accommodations for assistance animals are significantly increasing. In fact, such complaints are one of the most common types of fair housing complaints that HUD receives. Most charges of discrimination against a housing provider following a full investigation involve the denial of a reasonable accommodation to a person who has a physical or mental disability that the housing provider cannot readily observe. Okay, and now we'll discuss the process when a complaint is filed with HUD. Typically, the complaint will be handled by the Florida Commission of Human Relations, and that's going to be done in conjunction with the Department of Housing and Urban Development. So sometimes we have seen where a case or two has been handled directly by HUD, but typically it's going to be handled by the FCHR. So after a complaint is filed, the association will be notified of the complaint and they will have 10 days for filing a response. So typically it's going to be a statement of the case where you're going to have to, the association is going to have to come up with just an explanation of how it was, how the, most likely the denial was determined. And at that point, we suggest that the association seek counsel to defend the matter. Many times an insurance carrier will defend the case, but if not, we suggest that their general counsel handle the defense of the case. At that point, a response will be submitted, and FCHR will typically ask if the parties want to agree to conciliation. Now, conciliation, it's basically another word for mediation, where the parties will get together and see if they can get it resolved without going through the whole process. Now, if it doesn't settle a conciliation or the parties don't agree to conciliation, the next step would be the investigation. These investigations can be very quick. I've had one that's been over a year, so they can be lengthy as well. And what the commission will do is they'll investigate the complaint. They will speak with all, they can speak with all board members. They will ask for us to send over a lot of documentation. It'll typically be the governing documents. They'll want to see all the correspondence that went back and forth between the owner and the board, or the property manager. They'll want to see how other assistance animal requests were handled. So the process can be pretty lengthy, and there may be a lot of documentation that has to be provided. Okay, and at that point, there will be a decision made. If the director issues a determination of reasonable cause that there has been discrimination, the complainant may then file a civil action with the court or request an administrative hearing. So if a determination of no reasonable cause is issued, at that point, the complaint will be dismissed, and the complainant can then request an administrative hearing, but by statute, they cannot proceed to civil court. Okay, and as I mentioned, the sanctions for discrimination can be significant. Both the federal and Florida Fair Housing Act allow courts to impose actual damages and injunctions on defendants found liable for discrimination. So this may include damages for humiliation and embarrassment suffered by the plaintiff. It could be punitive damages when the defendant exhibited a callous indifference to the federally protected rights of the plaintiff. If the matter is instituted by the FCHR or HUD in an administrative hearing, the judge could provide maximum civil penalties as follows. So if it is the first instance that you're found guilty, that the association's found guilty of a violation, they can be fined up to $10,000. If there is 2 instances within 5 years, it's $25,000, and then 2 or more could go up to $50,000 if the violations are within 7 years of each other. Okay, and as for the attorney's fees for defending the claim, so if it is not picked up by the insurance carrier, and your general counsel is going to be defending the claim, the Federal Fair Housing Act, they will handle prevailing party attorney's fees a little bit differently than Florida Fair Housing Act will. So the Federal Fair Housing Act makes attorney's fees available to the prevailing party, but case law construes the act to not allow fees to the plaintiff and the defendant on an equal basis. Prevailing defendants are treated differently from prevailing plaintiffs and are only entitled to receive fees upon a finding that the plaintiff's actions were frivolous, unreasonable, or without foundation. So it may be difficult, even if you prevail, to actually receive attorney's fees. And under the Florida Fair Housing Act, if the court finds that discrimination has occurred, it will issue an order prohibiting the practice and providing affirmative relief from the effects, including an injunction and other equitable relief. It could be actual or punitive damages and reasonable attorney's fees. However, there is no language in the act allowing a prevailing defendant to receive attorney's fees. So the sanctions are pretty high. So if there is a wrongful denial, and if it is, or if it's determined that there is discrimination, so aside of the fact that there could be a pretty significant sanction, they'll also be hit with a pretty high amount of attorney's fees. If it's a case that, like I had, went on for over a year, that association was about $15,000 in because it was such a lengthy investigation process. Okay, and here are some common questions that we see come up. So I'll go through these, and then if we have any other questions, Rain can speak to them. First, does the owner have to take the assistance animal with them when the owner leaves the unit? So we have that come up many times where they're saying, well, this person needs an emotional support animal. Why is it that they can go to work all day and they don't need the emotional support animal when they're at work? HUD has stated that despite them being able to leave for the day, they may only need that comfort when they're home. That is maybe sufficient to get them the comfort that they need. So despite the fact that they are away from the unit and they leave the dog or the animal at home, that is fine. Can the association require the owner of the assistance animal to submit forms for approval? We do have some associations that they have passed a resolution, that they have a packet of papers that they ask that they fill out to actually get approval. While you can use those forms, it should be stated on the forms that they are not required. The only thing that is required is that documentation, which we already discussed. So if they come back and they say, nope, we don't want to fill out these forms, but here's our letter, then that's fine. They should not be required to fill out the forms. Can the association require the owner of the assistance animal to submit registration paperwork? Yes, they can do that. However, if you have a pet policy and they do not have to register pets, or this often happens with vaccination requirements, if they don't, the association doesn't require proof of vaccinations for their regular pets, they cannot require it only of assistance animals. But by all means, if you do have a registration process for pets, or you're a no pet association and you want to institute a registration process for assistance animals, you can certainly do that. Can the owner of assistance animal request a fence for the assistance animal? Yes, they can do that. In the instance I have with the horse, the owner asked if he can put a fence out back of his unit to allow the horse to graze out there, and it had to be approved. What happens if the animal shows signs of aggression? So if you have a dog that may have attempted to attack somebody, at that point, you cannot ask for the dog to be removed based on one instance of aggression. It has to be more than one. So after the first instance, what you can do is you can send a letter to the owner saying that anytime the dog is outside, the dog has to be muzzled. After that first instance, if you now on a second instance, after the second instance, that's when the dog can be removed. What can you do if the animal barks all day? At that point, the animal is considered a nuisance, and that would be a separate covenant in the documents, the nuisance provision. And we would first recommend sending a letter saying, you know, your dog is a nuisance, you have to stop the barking, or we may seek to have the dog removed. What if the association becomes aware that a neighboring resident is harassing an owner of an assistance animal? We see this happen pretty often. We have an association right now where one of the owners is highly upset that a neighbor has a pit bull in a no pet association. And what needs to be done in those instances where you may have a neighbor who, when the owner of the assistance animal goes outside, this neighbor is constantly harassing them. It's the association's obligation to send a letter to the harassing neighbor stating that they have a federally protected right to have that animal. So the association has to do some due diligence in protecting the owner of the assistance animal to make sure that they are not harassed by other owners in the association. All right, so, and I also put my email address up here. Feel free after, if you have any questions that come up after the seminar, I'd be happy to answer them. You can just shoot them to my email address there. In the meantime, Rain, if you want to see if there's any other questions, we'd be happy to answer them.
Oh yeah, I have
Christy, let me point out your email address is incorrect. You've got GADD.
Oh, I apologize for that.
So we'll correct when we're going to send out this webinar. We'll correct it so you'll all have the proper one.
All right, wonderful. Well, I think about 20 different questions that have come in via email, the questions, the chat. So I'm just going to start going through these. First one I have here, it says, our previous board of directors adopted a rule that required owners of emotional support animals to muzzle their pets while in common areas. Is this appropriate or legal?
I would say it's not appropriate. Typically, we've seen where HUD has stated that when they show a sign of aggression, that they can require them to be muzzled. But I would not say it's appropriate to muzzle just out walking, and if they've never shown any aggressive tendencies in the past.
Okay. Our next question. The condo rule is for one pet that has to be under 25 pounds. There's an owner that has one small dog, which is approved. And then later, that same owner's daughter has another dog that's about 50 pounds, which is too large. They're identifying that dog as a service animal with all the necessary paperwork. Does the service dog count as one dog, or is the service dog invisible? Meaning, is the owner allowed to keep the second dog?
Yeah, and Richard, feel free to jump in if you want at any time. But yes, so the smaller dog should be allowed as the pet, and then that second dog, because that is the assistance animal, that one does not fall under the pet policy, so that dog should be allowed if it has that proper documentation.
Next question I have. Is it permissible to have the doctor who submitted the letter for the patient be the patient's husband? Is there something an association needs to check before accepting that letter for an emotional support animal?
There's nothing in the statute that would prevent. There's nothing that states that, you know, it can't be a conflict by way of family, but I would think it would be questionable, but I wouldn't deny it based on that. I mean, if it's a licensed provider, they can state they have a disability. I would think it should be approved. I don't know, Richard, if you feel the same way, but
it's, you know, we've seen all different permutations of getting around these rules, and we laugh and we just scratch our head every time. I would say it would be allowed. This is similar to one we had where a male was seeking the assistance animal, and the doctor's note was from a gynecologist. And we inquired of the gynecologist, what would you be treating the male for? And he said his subspecialty in medical school was mental health. So he does that kind of on the side. That's how they got around that.
Interesting. All right, the next question I have is, are we as a board member allowed to ask for proof of the animal's state approved papers? I'm not too sure what that means, but it's saying the animal's state approved papers.
No, I would say no, because for an emotional support animal, you don't need to show any type of training or, you know, any type of documentation other than what we discussed. And for a service animal, you don't have to show documentation. So I would say no, there's no state approved papers.
Okay. And clarification on this one, can a unit owner or resident of a condo or an HOA have more than one service animal or more than one emotional support animal?
Yeah, and I addressed that. As I stated, we had two owners in a unit who had 6 dogs, 3 disabilities each for each person. Each dog ameliorated a symptom of the disability, and they had to get approved.
Okay, and the next question of, we were talking about all of this, does it also apply for renters? And is there any difference between a condo and an HOA?
It does. It applies to renters, owners, just the same.
And guests. It applies to guests.
Correct.
Okay, and some of these we may have already addressed. My apologies on it, but question is, if an emotional support animal, is the owner allowed to leave the pet at home and do things without the owner? And can the owner leave it with a pet sitter for days or weeks on end?
Yes, that question comes up all the time, and it is fine. It was actually addressed in HUD guidelines. And that is fine. If they leave the pet at home or they leave for vacation and they don't take the pet with them, that's okay.
Okay. How about this question? I guess we can interpret it a couple of different ways. The question was, can we charge a fee for cleaning up dog hair after their stay? So that may apply to something like a guest suite, but I wonder if maybe it could be expanded even more to think about if they're allowed to have pets in certain clubhouse and other common areas that have to be additionally cleaned for the pet hair. Could there be a fee for that cleaning service?
What would you say, Richard?
I think there could be a fee if it was applied to all dogs, you know, not just service dogs, but you would have to directly show there was a cause and a need for the cleaning, not just make it inconvenient to the person to dissuade them from bringing it to the clubhouse. HUD would look very closely at that.
Okay. Can the association be sued if a renter is bitten by another renter's emotional support animal?
The association could be sued if they were aware that this dog had an aggressive tendency and kind of ignored it. They might have some liability, but if it was a first time act, I don't think the association would have much liability in that case.
Okay. Here's the question. Does the animal have to wear any type of vest?
No, they cannot require that the animal wear a harness or any type of special item.
Okay. This may go with it. The same person asked this. They also said, does it have to be tethered or leash restraint? And they identified here in a PTSD animal checking an area prior to disabled to enter the area for safety. I'm not too sure.
You mean they allow the dog to go in and kind of scope out the space before the owner comes in, so they have to keep him off the leash for that? Is that what I think I'm understanding?
I think so. I mean, literally what the comment says, it says tethered or leash restraint in PTSD animal checking area prior to disabled to enter for safety.
I think you'd have to give an exception to the leash rule if that was necessary for the person's condition. I think that's what HUD would say.
Okay. Does the dog or horse have to be professionally trained to complete tasks to be considered a service animal?
Yes.
For a service animal, but not,
Yeah.
not an emotional support animal. That's the big difference.
Okay. Can the person with a disability foster kittens because they bring ease to the disability for like anxiety and depression?
That would be, I mean, that would be the same as any other emotional support animal. As long as they could get the documentation to show they need those kittens, then that would be sufficient.
Interesting. I mean, I love to foster kittens too. It brings me a lot of joy. So,
I mean, they would have to show that they have that disability and, you know, those kittens ameliorate the symptoms. But if they can show that, which I'm sure they will find a doctor who can say that, then they have to be approved.
do short-term renters, meaning vacation people who come for 1 to 3 months and or guests have to follow the emotional support animals? Do they have to be, can they be allowed to use the emotional support animals?
Guests are subject to it. And as far as, Richard, I know we dealt with this in the past. Do you recall what?
Yeah, I think the idea was that if the place allowed short-term rentals, it's more like a hotel, and they would not have to allow emotional support animals because they would be under the ADA, which doesn't recognize emotional support, only service. I think you're cutting a very fine line there, and would not recommend trying to do that really unless you truly are a hotel or a condo hotel with no long-term residents, because again, you know, we're as frustrated as all the people asking these questions are, because in 29 years of doing this, and Christy's probably been doing it, I don't know how long, I think I've seen 3 true service animals, which were obviously people with eyesight problems, the seeing eye dog. I've seen that maybe 3 times in almost 30 years. And every other one, I honestly believe is simply a manipulation of the system to get around the pet rule. That's just my cynical view of looking at this. But rolling the dice and pushing back beyond what you're allowed to do, you're just asking for that fair housing complaint. And although I think we win 95% of them, finding of no cause, it's hell, okay? And it's expensive and it's frustrating. So just going through the system is enough penalty to avoid it, even when you win.
Right. This one, it says, from my foreign second home residence, do we have to accept an emotional support animal letter from an out-of-country doctor if it meets the statutory requirements? Or can we require a letter from a local doctor?
We had an international letter that came up, and I told them that they should hold it to the same standard as an out-of-state letter. So if they can show that they actually did have one in-person visit or it was a telehealth provider, then it should be approved.
Can you require an insurance policy in case there's a bite or attack?
No, you cannot.
When a homeowner has a guest with an animal, states that the animal is an emotional support animal, is the guest animal required to present the same documentation?
Yes.
They are, but oftentimes we'll see guests are so fast in and out that it doesn't, they just bring the animal and then it's too late and they're gone. But if they're going to be there for an extended period of time and the animal is going to come back, then yes, they follow the same standards.
Okay, this question says, is it necessary to change the original governing documents, which states no dogs allowed, to avoid potential liability issue, or is it just okay to continue to leave the rule as it's stated?
My recommendation would be, if you can, change that language, because somebody will read it and think, oh, I'm not allowed to have this, and that could turn into a HUD complaint or a fair housing complaint. So I would clarify that language, or at least make it clear for people that that doesn't mean you don't get the service animal or the emotional support animal. Another thing I want to say, people, they use the term ADA and service animal when 99% of the time what they're meaning is the Fair Housing Act and an emotional support animal. They just know those first two terms much more commonly. So when they come in and they're saying it's a service animal under the ADA, you know, you just assume what they really mean is it's a emotional support animal under the Fair Housing Act. Almost always is what they really mean. So just because they're using the wrong words doesn't mean you can deny them.
A couple questions we have about cats. A question here, do you guys have any idea why cats are not considered service animals?
Most likely because it's just hard to train them like it is a dog or a horse, because they have to, again, service animals have to be specially trained.
Here's an interesting question about the cats. Are they allowed to let their cats roam free outside? Now, I don't know if that's a general term as in a pet, or if they're saying a cat is an emotional support animal, if they're allowed to let them roam free outside. But would you maybe answer both options?
I would say no to both, because ordinance, most likely the county ordinance will not allow the pet to roam outside, and same goes for the assistance animal.
As far as cats not being trainable, I think Siegfried and Roy made a whole career out of training cats. So I think they are trainable to jump through fire hoops and things.
Well, the average house cat can't do much other than get to its litter box and run to the food bowl. So, all right. Can we require adults only walk the dog? And I think they're kind of applying a service animal or an emotional support animal.
I would say no, because if you have a disabled person who it's a mobility, if they need that animal, but for some reason they need a kid to walk the animal, then that should just be part of the reasonable accommodation. And there's typically no rules saying a kid can't walk a pet. So no, I mean, they have to be able to have proper control over the animal, but otherwise it should be allowed.
Okay. Question here. A previous board sends a letter to the doctor from a Cleveland clinic to make sure that they do indeed see this person. And if not, and it says, and if not, the board will have their license revoked. Is this okay? Let me repeat the question again because it's a little choppy when I read it. A previous board sends a letter to the doctor from a Cleveland clinic to make sure that they do indeed see that this person, and if they don't do this, will the board have their license revoked? Is this okay?
Do you want me to answer?
They can inquire of the doctor to make sure that either he or she provides telehealth or has seen the person, if they're an out-of-state doctor. As far as threatening to get their license revoked, I wouldn't do that. I don't think they could do that under that circumstance, but I don't think you should use threatening language like that under these circumstances.
Does a service animal have to have legal paperwork showing that they are a true service animal? Or can anyone train the animal and show it completes a task?
The dog has to be specially trained, so they have to be able to show that it does a task. You can't require documentation of the training.
Okay. We're a no animal community. Do we need a rule regarding medication, shots for emotional support animals, etc.? Should we get them?
Typically, we suggest that the community adopt a resolution dealing with emotional support animals. If they are going to require certain vaccinations or registration, they should put all of that into a resolution, so they have, a basis to enforce.
Okay, a couple more questions. Dogs can live a long time. How often does an animal need to be recertified? The person's disability may not be long-term.
Only in the event that the letter states that it's a temporary disability can you then request another certification. I actually asked one of the investigators this question when we had a recent case, and the investigator told me that if the disability is based, and now again, you can't ask, but say they offer information to say that you can be disabled based on pregnancy, they told me. So if that is the basis for their disability, and the board clearly sees, 9 months later that the woman isn't pregnant anymore, at that point, you can ask for recertification. But if there is nothing in the documentation to show that it's a temporary disability, you cannot ask for further certification, no matter how far in the future it is.
And the temporary certification will become the permanent one overnight when they get the doctor to just change the words.
Okay. What recourse do we have if the emotional support cat does roam outside and we have proof?
We typically will send a violation letter stating that we understand it's an emotional support animal, and you gotta word these letters very carefully, because you want to make sure that it doesn't look to be any language that they're going to consider as discriminatory. So we very nicely say that, we've seen the cat roaming outside. It's not allowed to roam outside. If it happens again, we may have to remove the cat. And then even after that, I typically do one more final warning letter before we would actually try to have the animal removed.
Okay. If the governing documents already require insurance and vaccinations, does this apply to service animals and emotional support animals as well?
You can do the vaccinations. However, there is specific HUD language in one of their guidelines that say that you cannot require an owner who requests a reasonable accommodation or modification to obtain an insurance policy based on the accommodation.
If an emotional support animal dies, does the owner need a new letter for a new animal?
They do not. They can use that same documentation and get a new animal.
Okay. This question, I think we may have partially answered it. The question is, we have a guest wanting to bring their visitors to come and visit while they're staying. Their visitors have an emotional support dog. Can we deny them as they are not our guest?
No.
I would think they're still a guest of the association. They would still have to be approved.
Okay. I think we have answered all of our questions and comments that we have. I'm going to give it maybe about another 15 to 30 seconds just for anybody to type in any last questions that they had, but it was super informative, everything Christy and Richard that you guys have gone over with us today. We've answered tons of questions about dogs and cats and horses. I think some of these are very informative, and it's definitely unique and interesting to kind of hear all these facts, because it's not, I think, what the general public has the impression of the way things follow. And for a lot of board members and managers, I think there has to be recognition that a lot of the laws, in fact, are to help those people that have the disabilities and that have, they need some of these animals for support for whatever reasons. 2 more questions have come in. Can the board have a 30-day period for approval?
Yes, when a request is made, the animal should be deemed approved until denied. So what we do is when we review the documentation, if we need additional time, we'll reach out to the owner, tell them it's being investigated. We will get back to them, but in the meantime, the animal should be approved. So we would certainly suggest that you try to have that approval process done within 30 days. If it's something where they need to go back to their doctor and they can't get an appointment, then we would suggest you extend it as long as they are working towards getting that documentation.
Another question that came in a condo situation, can we video a common area to show proof that an animal was outside?
I always suggest that if you do have an issue with an assistance animal where you see one is roaming, typically I don't like doing anything on it until I actually have that proof. I tell them, have the neighbor or whoever get some kind of videos or photos of the dog out roaming, because once you get into the investigation period, it's hard, it's going to be our word against theirs. So the best evidence is going to be if we have that video or some kind of photo. I wouldn't make it obvious because you don't want to make it go into like a harassment type situation. But if you see the dog or the cat's out roaming and you can snap a picture or video of it, get it.
The same person who's had a couple of questions to us about the guests. I think they're looking for further clarification on this. And they're saying, do we ask the guests there on site for the paperwork? We usually require a 2-week in advance for documentation. And I think this is talking about when they're getting a guest that's coming with an emotional support animal. Do they ask physically the person that's there on site for the paperwork? And I think what the comment is that they usually get that paperwork several weeks in advance of their stay.
I would suggest that if it's somebody who's going to be coming repeatedly, that you ask that they do provide the documentation. You do approach them and ask for it. If it's something where it's going to be a guest who's just there for the day, or a few days, they're likely not going to have the documentation. They're just going to tell you it's an emotional support animal. And in those instances, I would probably just leave it go. It's probably not worth dealing with. But if it's something where they're going to be there for an extended period of time or, on numerous occasions, at that point, I would absolutely suggest that you request the documentation.
Yeah, if they're there for a short period of time, you say, hey, guests aren't allowed to have dogs, and they say it's an emotional support dog, then I would tell them, well, if you intend to return next time, please provide the paperwork. But if they're only there for 2 or 3 days, it's just not worth it. You're not going to get it. They're going to be gone. But just tell them when you come back, if you think you're coming back, you need to provide it.
Hey, somebody else had the question again about the guests. And it says, how do guests fall under the FHA since we're not denying housing since they don't actually live there?
I had this situation with HUD. The lady had a parrot. She was a guest. And I just called HUD and said, does it apply to them? And they said, yes, because part of being a resident is, you have guests come over. So it applies to guests. Even though you're not providing the housing, they're not literally maybe spending the night. It's still part and parcel of the right of the homeowner and falls under what people do that live in houses.
All right, wonderful. Well, I think that was our last question that we had. Christy, again, I can't thank you enough for joining us and for sharing your expertise with us. Richard, as always, it's a pleasure to be presenting alongside of you. And to everyone who attended, thank you so much for joining our presentation. We'll be here again next month with a new hot and coming topic. And we look forward to seeing you all then. Thank you all.
And we will, Rain, are we going to send this out to everybody on the mailing list? This
Yes, we will be
PowerPoint?
sending
Okay.
out a copy of this presentation to all those in attendance.
Okay, great. Thanks.
Thank
Thank
you
you.
all.
Bye-bye.
Bye-bye.